Hey guys and gals, this is the Bar Exam and Chill podcast. I'm your host TJ. Today we have a hypo from the California February 2017 bar exam. Let's hop right into it. This is from question 3. Pete sued Donna's Pizza in federal court. At trial, in his case in chief, Pete testified that, as he was driving his car one day, he entered an intersection with the green light in his favor. He further testified that when he entered the intersection, Aaron, an employee of Donna's Pizza, was driving a company van, ran a red light, and collided with his car. He sustained serious injuries as a result and was taken to the hospital. Pete then called Nellie, a nurse, who testified that she treated Pete when he was at the hospital. Nellie testified that Pete told her that, during the collision, his head struck the windshield and that he was still in a great deal of pain. Nellie, pursuant to standard hospital procedure, recorded the information on a hospital intake form. Pete moved the hospital intake form into evidence and rested. During Donna's Pizza's case in chief, Aaron testified that she had the green light and that it was Pete who ran the red light. Donna, the owner of Donna's Pizza, then testified that Donna's Pizza was not responsible for the accident. On cross-examination, Donna was asked whether she had ever offered to pay for any of Pete's medical expenses, and she denied she had. Donna's Pizza rested. In rebuttal, Pete testified that, at the accident scene, Aaron told him, "I was in a hurry to make a pizza delivery, and that is why I ran the red light." Pete also testified that Donna visited him in the hospital and told him that Donna's Pizza would take care of all his medical expenses. Pete testified that Donna's Pizza, however, never paid for any of his medical expenses. Assume all appropriate objections and motions to strike were timely made. Did the court properly admit 1. The hospital intake form. Discuss. 2. Pete's testimony about Aaron's statement at the accident scene. Discuss. 3. Pete's testimony about Donna's statements at the hospital. Discuss. Answer according to the federal rules of evidence. So we've got question 1 here. This is about the hospital intake form. Our issue is whether the court properly admitted the hospital intake form over hearsay and other objections. And we analyze our rules here. Rule 1 that we're going to be analyzing is relevance. This is going to be where you start pretty much in every evidence essay. You're going to have the rule statement for evidence memorized and just throw it in at the top and say whether or not the evidence is relevant. It's probably going to be relevant, right? In most cases. It may be irrelevant some of the time, but typically it'll be relevant. But your rule statement here is that you got to have memorized. Evidence is relevant if it has any tendency to make a fact of consequence more or less probable. So there's your sentence. You have that memorized. You throw it in at the top of any evidence analysis. You say, is the evidence relevant? Well, what is relevance? Well, evidence is relevant if it has any tendency to make a fact of consequence more or less probable. This is coming from the Federal Rules of Evidence 401 and 402. You've also got your hearsay rule. This is the big famous one that everyone should have memorized from law school. So hearsay is an out-of-court statement offered for the truth of the matter asserted, and hearsay is inadmissible unless an exception applies. Multiple levels of hearsay require each level to qualify. So there's your rule statement for hearsay. You've also got your rule for business records exception here. A record of an event, a business record is a record of an act, event, condition. It's admissible if it's made at or near the time by someone with knowledge, kept in the regular course of a regularly conducted business activity, and it was a regular practice to make such a record, shown by the custodian or qualified witness testimony. The opponent may show lack of trustworthiness here. So you got your business records exception. There's your rule. Another rule here, statements made for medical diagnosis or treatment. So statements made for medical diagnosis or treatment are admissible. This is a little bit counterintuitive here. You might think that they be inadmissible, but this is actually an exception here. So statements made for medical diagnosis or treatment. Statements made for and reasonably pertinent to medical diagnosis or treatment describing medical history, symptoms, sensations, or their general cause and inception are admissible. Remember that authentication and foundation are required, but Nellie's testimony provides that here in this example. So we've got our rules. We go through them, right? Relevance, hearsay, business records exception, statements made for medical treatment and diagnosis, and we get into our application. Lay out your rules, and then here, the form is relevant to prove Pete's injuries and their causes, right? So it's relevant. We would just take our rule. Evidence is relevant if it has any tendency to make a fact of consequence more or less probable. Here, the form is relevant to prove Pete's injuries and their causes, head striking the windshield. This supports his damages and also, his argument for liability. So our hearsay analysis here is going to be the form itself is a business record. Nellie recorded per standard hospital procedure, which is given in the facts. She testified as a qualified witness. That's your authentication. Pete's statements within it qualify under the federal rules of evidence. It was made to a treating nurse for treatment. It described his symptoms and pain and the collision's general cause. The cause description is reasonably pertinent here. So it's not a present sense impression or excited utterance. You don't have those issues here. No undue prejudice. No undue prejudice outweighs probative value. That's your federal rules of evidence 403 standard. That's going to be your general bar. You're going to throw that in pretty much every evidence analysis. So anytime you're discussing evidence, you're always going to be like, is it relevant? You lay out the rule statement there. Then you've also got this like catch-all, the federal rules of evidence 403, which is it unduly prejudicial? Does it outweigh the probative value? You're just going to kind of make a judgment call there on whether it does. Here, it doesn't seem unduly prejudicial. So our conclusion is going to be the court properly admitted the hospital intake form. And again, you're going to go under this business records exception and you're going to analyze under the standard. So you've got the rule statement, you lay it out. What is a business records exception? Go through each of the pertinent factors there. The form itself is a business record. Nellie recorded it per standard hospital procedure. That's given in the facts. She testified as a qualified witness, authenticating it. Pete's statements were made to a treating nurse for treatment. He describes the symptoms and pain. The cause description is reasonably pertinent. So you've got the conclusion here, which is this should be admissible. This statement should be admissible. The hospital intake form is the statement here. I mean, it's a record, but it's going to be admissible. Question 2, Pete's testimony about Aaron's statements at the accident scene. So our issue here is whether Pete's rebuttal testimony repeating Aaron's statements, which is, quote, I was in a hurry to make a pizza delivery, and that is why I ran the red light, was properly admitted. That's our issue. Again, you lay out your rule statement here. Hearsay is an out-of-court statement offered for the truth of the matter asserted. And we've got an exception that we're going to analyze for this hearsay exception, the party opponent admission. This is really commonly tested on the bar. A statement is not hearsay if offered against an opposing party and made by the party's agent, employee, on a matter within the scope of the relationship while it existed. So if you've got here a party opponent here is going to be like, if it's just the defendant, anything they say is going to be admissible against them. But also, you've got an employee for Donna's Pizza here. So, is the employee a party opponent? Well, that's your standard. A statement is not hearsay if offered against an opposing party and made by the party's agent or employee on a matter within the scope of the relationship while it existed. So she's driving a car for Donna's Pizza. That's going to be your agent-employee relationship, and it's on a matter within the scope of that relationship while it existed. You have no need for personal knowledge or trustworthiness. These requirements are not needed here. So you've got a party opponent admission, and it does seem to be relevant. So each time you would just kind of throw in this relevance get an extra point there. Is it relevant? Yes, it tends to prove that Aaron and thus Donna's Pizza were responsible, right? Under the theory of respondeat superior. There's your fancy Latin phrase. That's just your employee relationship. So it tends to prove that Aaron ran the red light, right? She's just outright saying, hey, I was in a hurry to make this pizza delivery, and that's why I ran the red light. So is it relevant? Yes, it tends to prove that Aaron ran the red light and it was, in the scope of her employment duties. That is the reason why she ran it. So it's relevant. You've got it. It is hearsay. It's an out-of-court statement. She's saying, she didn't say this in court. I was in a hurry to make a pizza delivery. That's why I ran the red light. Hearsay, party opponent admission. You get into your application, apply the rules to the facts in the hypo. Erin's statement is hearsay if offered for its truth that she ran the red light due to being in a hurry. However, it qualifies as a party opponent. Erin was Donna's Pizza's employee driving the company van at the time. Statement concerns her driving and the delivery within that scope of employment and is offered against Donna's Pizza to prove liability. So timing at the scene does not disqualify it. It is also relevant for impeachment. It contradicts Erin's trial testimony and substantive proof of negligence and liability. It doesn't seem like it's unduly prejudicial. You might want to, every time you kind of just throw in that 403 exception and make a judgment call on whether it's, unduly prejudicial or if if the prejudice outweighs the probative value. There's your key phrase there. Here, it doesn't seem like its prejudice is outweighing its probative value. It's pretty probative, right? Because it's proving liability. It's a direct reason why she would have ran the red light. So our conclusion here is going to be that the court properly admitted Pete's testimony about Erin's statements as a proper party opponent admission. Nice and easy. We keep going down into question 3. 3 is going to be regarding Pete's testimony regarding Donna's statements. So our issue here is whether Donna's statement, quote, "we will take care of all medical expenses," and the fact that she, is that admissible? And also the fact that she did not pay the actual medical expenses. Is this admissible? So our rule is going to be, generally speaking, medical expenses. This is under Federal Rules of Evidence 409. Evidence of furnishing, promising to pay, or offering to pay medical, hospital, or similar expenses occasioned by an injury is inadmissible to prove liability for that injury. The purpose of this is to try and, facilitate humanitarian, like if you want to pay for somebody's medical expenses, they don't want to face the worry of legal liability. They want to try and help people, pay medical expenses if that's what they want to do. They don't want you to subject yourself to legal liability if you're offering to do something good for someone. So that's kind of the logic underpinning this rule here. If you do offer to furnish or promise to pay medical or hospital expenses occasioned by an injury, it's inadmissible to prove liability. Now, under this Federal Rules of Evidence section here, there's no, it can be used for impeachment. Sometimes these exceptions are explicitly, you can't, it's just barred outright. And the impeachment analysis wouldn't matter at all. But here, under this medical expenses, technically, evidence may be admitted to impeach a witness's credibility if they testify untruthfully about a specific fact. So there's a little bit of a nuance here. We're going to get into it in the analysis. Our application here. Liability, right? Under Federal Rules of Evidence 409, Donna's offer to pay for Pete's medical expenses is strictly inadmissible to prove that Donna's Pizza was at fault for the accident. The policy is to encourage humanitarian impulses without fear of legal repercussion, as we discussed. You kind of just put that in there. You've got your rule. It's the medical expenses are barred. They're inadmissible to prove liability. So we kind of talk about here, there's a rebuttal in the facts. So impeachment is going to be relevant. On cross-examination, Donna denied ever offering to pay. Pete's rebuttal testimony was offered to show that she lied on the stand. But this would kind of defeat the purpose here. So I think there's a really nuanced little issue in this hypo. It is going to be barred to prove liability. Can she offer it as impeachment? Well, it would kind of defeat the purpose of barring the evidence there if you could just ask somebody, hey, did you offer to pay medical expenses? And then if they deny, say, set up an impeachment. So courts basically, they will hold that you can't bootstrap inadmissible evidence into the record by asking a question on cross-examination that will trigger a denial or an admission, right? Either way, if you set it up on cross-examination, you say, hey, did you ever offer to pay for his medical expenses? You're in a fucked situation, because if you admit it, then it can be, it might be that the jury's going to use it against you. And if you deny it, the lawyer can then just say, oh, I'm not using it for this improper purpose that the rule is established for. I'm just using it to impeach them. That is not going to be a proper use of the court, right? I mean, the court's probably not going to want you to just defeat the whole purpose of the rule by setting up on cross-examination, setting them up to bootstrap in this evidence. So you have a little nuance there. Under 409, evidence of furnishing, promising to pay is not admissible to prove liability. It doesn't have this. It doesn't have this typical bar in the federal rules of evidence against all uses. In this one, it can be used for impeachment, but here, because it's set up in cross-examination, it seems like it's not really a proper use of the questioning. So we would probably argue, Donna's Pizza is going to argue that this was use of a calculated cross-examination question, knowing that a denial is likely, solely so that they can open the door for otherwise inadmissible evidence and an extrinsic impeachment. If the plaintiffs can routinely ask about unmade offers, force a denial, and then rebut with the offer, it kind of chills the very conduct that 409 seeks to promote. So here, it seems like we've got a pretty nuanced little analysis here. And if we go through all of the analysis here, it seems like you kind of come to either conclusion here. Possibly you just say, hey, this is used for impeachment purposes, which is not barred under this federal rules of evidence for the hospital for offer to pay expenses. You might then conclude that it is admissible, but I would say that many courts are not going to allow you to bootstrap in otherwise inadmissible evidence by setting it up on cross-examination like they've done here. If the matter is collateral, meaning it's only relevant for credibility, not a core disputed fact like that's at issue, then the extrinsic evidence is often barred after a denial. Here, Donna's denial on cross, I never offered, directly contradicts Pete's rebuttal account, but the underlying offer's primary relevance is, whether they offered it in the first place. That's precisely what the 409 is supposed to shield. So a court could, sustain an objection to Pete's rebuttal testimony if the sole or primary purpose appears to be circumventing the rule via sort of a manufactured impeachment. It kind of gets around the ultimate policy purpose of that offer to pay medical expenses. So here, there's a little nuance here. I would say in this one, again, you could probably come down on either side of this conclusion, but I would say even if it's used for impeachment, the statement's prejudicial effect regarding liability violates the policy of FRE 409. So the court should have excluded this testimony concerning the offer to pay medical expenses. That's where I would come down on this. But I think as long as if you're going through the analysis, you're properly weighing both sides of the argument here, it's probably not super important where your conclusion lands. It seems like it could go either way. And it depends, again, on if whatever the judge you get. The judges can come down on either side of an issue. So I don't think the conclusion is always going to be the most important factor for whether you're getting points on the bar exam. As long as you're going through like, hey, we've got a statement, it's hearsay, do any exceptions qualify? You analyze the proper rule statements for the exceptions, and then you make your conclusion there. You should be okay. We've got our evidence questions here. We've analyzed all the proper standards, so hopefully this is going to be helpful for you going forward. And that's all I got for today. We've answered it. Happy studying, everybody.